So think about this for a second. The U.S., founded on liberty, but its incarceration rate, it's like 5, maybe 10 times higher than a lot of other Western democracies.
Yeah, it's a stark contrast. And that big divergence really kicked off around the 1970s.
Exactly. So today, we want to look at the core ideas behind American justice and how maybe interpreting them has led us here to these kinds of unexpected places.
We're drawing a lot from legal analysis, particularly Rachel Elise's work in Justice Abandoned.
Right. And our aim here is really just to give you a clear, insightful look at these really critical issues.
And, if you want to explore complex topics like this further and really get into that critical thinking space, checking out channels like Mindful Moments on YouTube could be interesting. They do AI book analysis.
Good suggestion. Okay, so let's get into it. The framers of the Constitution. What was their mindset with criminal justice?
Well, it's fascinating, actually. They were reacting to some serious government abuse they'd seen or experienced. Think England's bloody code, the power of kings.
Right, so they were wary, deeply suspicious of government power in criminal stuff.
Exactly. And because of that, they very deliberately built in all these safeguards for individual liberty right into the Constitution.
You can see it in the structure, can't you? Like, punishing someone wasn't supposed to be easy. It takes all 3 branches agreeing. Congress defines the crime, the executive enforces, the judiciary, often a jury, decides guilt.
That separation of powers is key. It's an inherent check. Yeah. And it goes for the first station. The Constitution has tons of provisions, covering everything from the investigation phase right up to punishment.
All designed to limit government power.
Precisely. For the framers, preventing the government from abusing its power to punish was arguably more important than just efficiency in catching criminals. They were scared that making punishment too easy would be the real threat to freedom and safety.
So if we look at today's high incarceration rates through that lens, the argument isn't that the Constitution itself is flawed?
Not necessarily. The argument presented is that maybe we've strayed from those original checks and balances the framers intended.
Which kind of leads us to a really crucial area. Pre-trial detention. How we decide who waits for trial in jail.
Yes, and there was a big shift there starting around the 70s. Crime rates were up. You had this tough-on-crime politics. And suddenly, the idea of detaining someone before trial based on perceived dangerousness really took hold, not just flight risk.
And the human cost. I mean, there are stories like Dwayne Tomlin at Rikers, held for weeks over a clean straw in terrible conditions.
And then the case is dismissed. It really highlights the potential for, profound injustice when you lock someone up before they're found guilty of anything.
So bail reform initially wasn't about dangerousness. It was just about making sure people showed up.
Primarily, yes.
Yeah.
Making sure they wouldn't flee. But then you had figures like Nixon talking about detaining dangerous, hardcore recidivists. That idea gained momentum.
And influenced laws like the Federal Bail Reform Act of '84.
Exactly. And there were important differences between, say, the earlier D.C. law and that federal act.
Like the time limit. The D.C. one had it, the federal one didn't.
Right. And also the standard of proof needed to detain someone for being dangerous was lower in the federal law.
Then came the Supreme Court case, United States v. Salerno. That seems pivotal.
Oh, absolutely. The court made this really controversial call. They said holding someone pre-trial to prevent future danger wasn't punishment. It was regulatory.
But wait, isn't preventing future crime like a major goal of punishment itself? Incapacitation.
That's the counterargument, and it's one the court itself has recognized elsewhere, that incapacitation is a core penal justification.
So calling it regulatory feels a bit thin.
It raises huge due process questions. I mean, the idea is consequences follow guilt, right?
Yeah.
Unless it's strictly necessary to preserve the trial itself, stopping someone from fleeing or tampering with witnesses.
And this dangerousness standard wasn't just for adults, was it? There were Shelby Martin for juveniles, too.
Yes, applying a similar logic, detaining youth based on a serious risk of future offenses.
The scale of this change is just, wow. Pretrial detention rates went up how much?
Between 1970 and 2015. A 433% increase. Astonishing. It's just become normal.
Despite the costs, losing jobs, kids, even making reoffending more likely.
Despite all of that, yes, it's deeply embedded now.
Okay, let's shift gears a bit. The image we have of justice, the courtroom drama, the trial, that's not really the norm anymore, is it?
Not at all. The reality today is mass plea bargaining. That's how most criminal cases are resolved.
Which is interesting because the framers saw the jury trial as so fundamental.
Absolutely vital.
Yeah.
A check on government power, part of the separation of powers.
Yeah.
They saw it as this crucial buffer between the individual and the state.
But over time, that respect for the jury seems to have faded, at least among legal elites, more focused on just court efficiency.
You could argue that, yes. And this ties into the idea of unconstitutional conditions.
Meaning?
Well, the argument is that basically any incentive the prosecution offers to get a defendant to waive their jury trial right is unconstitutional because you're essentially putting a price tag on a fundamental check on government.
But the Supreme Court hasn't seen it that way. They've accepted plea bargaining.
Yes, in cases like Brady v. United States, they called it an important component of the system.
There's that case, Bordenkircher v. Hayes. The prosecutor threatening a life sentence over check forgery if the guy didn't take a 5-year plea.
That case perfectly illustrates the coercive power involved. It shows how plea bargaining can lead to convictions without a full trial, maybe even inaccurate ones, because the pressure to plead guilty is just immense.
Especially when facing such a drastically higher sentence if you go to trial and lose.
Exactly.
Okay, let's talk about sentencing itself. The Eighth Amendment. We hear about these incredibly long sentences for, frankly, minor-sounding crimes. Life for shoplifting. Decades for stealing videos.
Right, it raises huge questions about proportionality. Is the punishment fitting the crime?
And historically, the Eighth Amendment's ban on cruel and unusual punishments did cover disproportionate sentences, didn't it? Not just barbaric methods.
That was the understanding, yes. Both the method and the severity relative to the offense.
But the Supreme Court seems to treat non-death penalty sentences differently now. Less scrutiny.
That's a really key point. They review capital sentences much more rigorously for proportionality than non-capital ones.
And you had Justice Scalia in Harmelin v. Michigan arguing against proportionality review for non-capital cases altogether.
He did, which was a break from that older understanding and from dissents like Justice Fields way back in O'Neill v. Vermont. Even Justice Kennedy's test from Harmelin is pretty limited in practice.
Which brings us back to cases like Lockyer v. Andrade. 50 years to life for stealing videotapes because of prior convictions and a 3-strikes law.
It starkly shows what can happen with limited proportionality review. It's quite shocking when you see the details.
And what about inside prisons, the conditions? The Eighth Amendment applies there too, right?
Yes, and for a while, lower courts were quite active in using it to challenge inhumane conditions.
But then came Rhodes v. Chapman, the Supreme Court decision on overcrowding.
That was a turning point. The court reversed a lower court that found double bunking 2 inmates in a cell meant for one unconstitutional. It signaled a shift towards less judicial oversight.
Even though overcrowding has serious impacts, health, safety, resources.
Definitely. It affects everything. And other cases like Bell v. Wolfish also made it harder to challenge conditions, especially for pretrial detainees.
And things like medical care remain a huge problem. You mentioned California needing a federal receiver.
Yes. The system failed so badly that the federal courts had to step in to oversee health care. It shows the depth of the problem.
Okay, let's move to the Fourth Amendment. Search and seizure, the stop and frisk issue. Terry v. Ohio seems like the landmark case here.
It was a massive shift. Terry allowed police to stop and frisk someone based not on probable cause, but on a lower standard, reasonable suspicion.
And the argument is this essentially legalized something that was previously unlawful for centuries under common law.
That's the critique, yes. It lowered the bar significantly.
We hear stories about the impact people stopped outside their own homes, searched for a bulge that's just, keys or a wallet.
Right. And groups like the NAACP Legal Defense Fund warned early on about the negative effects, especially in communities of color, how it could erode trust and cause unrest.
And reasonable suspicion is much lower than probable cause, which ideally needs a warrant based on actual evidence.
Much lower. And the requirement for warrants has been significantly diluted in practice.
Plus, the data shows clear racial disparities, right? Black individuals stopped far more often.
Undeniably. Both in traffic stops and pedestrian stops, the statistics show significant racial disparities.
And the scope of permissible frisk seems to have expanded, too. Suspected drug crimes being in a high-crime area, often on pretty flimsy grounds.
Yes, the justifications needed have become less stringent over time, further chipping away at those traditional Fourth Amendment protections.
Which leads us right into the 14th Amendment and racial bias across the whole system.
It's a pervasive issue, unfortunately. The data shows disparities at so many points: policing, plea deals, sentencing.
Like who gets charges dismissed, who gets offered better pleas, who gets hit with habitual offender charges.
All of that. And sentencing length disparities, too.
But then you have the Supreme Court in McCluskey v. Kemp. They rejected broad statistical evidence of racial bias in death penalty cases.
They did. They set this incredibly high bar, requiring proof of intentional discrimination in that specific individual case, which is notoriously difficult to prove.
Even though the 14th Amendment's Equal Protection Clause was meant to stop racial discrimination in law.
That was its core purpose. But proving discriminatory intent, especially in things like selective prosecution after United States v. Armstrong, is extremely challenging.
So the argument is the court's standard ignores things like implicit bias or systemic issues.
Exactly. It demands a kind of smoking gun proof of explicit bias that often just doesn't exist, even when the discriminatory effect is clear.
The NYPD stop and frisk case was unusual because they did find direct evidence of discriminatory purpose.
That was a rare instance, yes. Generally, meeting that high bar is the exception, not the rule.
So when you combine the court's reluctance to tackle racial bias head-on with its limited review of sentences, you can see how it fuels disparities.
It creates a situation where systemic bias can persist and lead to harsher outcomes, particularly for people of color, without effective judicial remedy. Thinking about these complex societal intersections, well, it underscores the value of resources that encourage critical thinking, like we mentioned with mindful moments, or, frankly, the kind of discussions we aim for here.
Absolutely. So looking at the big picture, the analysis in Justice Abandoned really points a finger at the Supreme Court's interpretations as a major driver of mass incarceration.
That's the central argument, that these interpretations, perhaps influenced by the political climate or a reaction against earlier court decisions expanding rights.
The Warren Court era.
Right. That these later interpretations have significantly weakened the Constitution's intended protections.
Which makes Supreme Court appointments incredibly important, doesn't it? Advocates need to focus on these issues when nominees are considered.
The impact is just so profound and long-lasting in the realm of criminal justice, it has to be a priority.
So, to sum up, the Constitution seems to offer strong protections against government overreach in criminal justice.
In theory, yes. Significant safeguards.
But the way the Supreme Court has interpreted those protections in key areas has arguably diminished them, and that's contributed to mass incarceration and racial inequality.
That's the core thesis we've been exploring.
So hopefully you now have a deeper grasp of the constitutional issues involved, the history, the legal shifts that got us here.
And maybe something to think about.
Yeah.
This balance we have now between public safety and individual liberty, does it really match what the framers envisioned?
That's the question to ponder. Is another way possible or even desirable? We hope you'll subscribe for more conversations like this. Share it if you found it valuable.
And maybe check out Justice Abandoned or related readings. You can find links for this recording.
Most importantly, just keep thinking critically about these huge issues that shape all our lives.